Hello, everybody, and welcome back to another episode of Things We Don't Talk About. We are your hosts. I am Mark Daniel Lamasti,
And I'm Stephanie Webb.
and today we are going to cover a very interesting topic: the trial by jury. This seems to be the vanishing right in our American justice system. So we often hear the phrase, "a jury of your peers" is a constitutional promise so foundational it shows up twice in the Bill of Rights. But how often does this promise actually play out in today's legal system? Why have the courtroom? Why has the courtroom become a place of quick deals and secret settlements instead of public trials and citizen juries? And what does this shift mean for your constitutional rights? So today we're going to take a deep dive into the slow and steady disappearance of the jury trial in America. From the 20th century through today, we'll look at how jury trials have been declining decade by decade, explore the legal tools used to bypass them, and unpack what it means for justice in the modern age.
So the U.S. Constitution guarantees the right to trial by jury in two key amendments. The Sixth Amendment guarantees a jury trial in criminal cases, and the Seventh Amendment guarantees jury trials in federal civil cases. Historically, jury trials were seen as a check on government power and elite influence. As Thomas Jefferson once said, the jury is the only anchor yet imagined by man, by which a government can be held to the principles of its constitution. So, there's been a huge decline in decades by these trials. And it's quite profound, actually. And we just wanted to talk about that a little bit today, because I feel like no one really talks about how really there's no jury trials nowadays.
No, not really. It seems like it's gone by the wayside more and more. I mean, I don't personally want to get that summons in the mail saying, "Hey, jury trials," but I can't anymore. As private citizens, we can't serve on a jury that unless if we're serving on a jury of state nationals. So
Because of our peers.
that's a really fun fact about changing your status. But as we continue to see this decline, I think that something that people need to take into account is that this is such a fundamental right. Okay. As we have kind of chipped away at our legal system, one of the words that was described was the word efficiency. They're stating that it's inefficient for our court system to operate through jury trials. So that's why there's plea deals. That's why there's secret meetings. There's all these different types of arrangements. And pretty much the point of all of this is so that you're not actually having some of these fundamental rights. So as this continues to happen, the question we really need to ask ourselves is jury trials a right? And if it is a right, then why don't we exercise it? Is it simply convenience? Because I would say that what I hear often from people when they say, "Do I have to serve on a jury?" is they're going to miss work, they're going to miss time with their families. They're not even necessarily wanting to go be part of this. But then at the same time, it's like, don't we also have this duty to society? If we all live here, can we not call on our neighbors and say, "Can we sit down and discuss a bunch of facts objectively and then come to whatever consideration, whether you're guilty or not guilty, or from a standpoint or from a civil, like, is there an equitable solution so that we can, move on and figure out how to move forward?" But hey, we're just not seeing as much of that. What's kind of interesting about, just throughout the history, so back in the 1960s, it was about 5.5% of civil cases went to jury trial. By the 1980s, this was down to 2.6%. In the 90s, it was just under 2%. And by the time we're at 2020, we're talking about less than 0.5%. That's civil cases. And I can understand that too. There's probably a different circumstances there where it's like, hey, this matter just doesn't actually need to be solved, right? Like, we've all, wronged our neighbor or something and stepped on something and was like, hey, let me bake you a cake or whatever the heck I can do to, solve the situation. We don't need to make a big deal out of it. Yeah.
Right. No one files a motion. The court just never moves forward with the case.
Yeah.
There's a bunch of those.
Right. Exactly. It's like cases are left open. Nothing's really happening. So, this can. But if we're looking at it from a criminal standpoint, so going back to again the 1960s, it was about 8% of criminal cases in the federal court system went to trial by a jury of their peers. In 2013, we're talking about down to about 4%, and now in 2020, it's at less than 2%. So literally 2 out of 100 cases are going to trial. I don't know. Do you think that this is a good thing or a bad thing, Steph? What do you think about this?
It's shocking that it's less than 1% nowadays that go to trial because it just doesn't really make sense that
Okay.
80 years ago we were up to 5.5%. And that's quite a lot compared to half a percentage. So it's like they've really tried to sort cases and make it go certain routes now, like arbitration, where you're just literally just conferring in a room and whatever you guys decide on, you and the lawyers decide on,
right,
is binding, and then that's the decision, and that's what you have to go with. There's a lot of arbitration clauses out there, and the court system is bogged down with all of this, but now so many people are doing arbitration that I feel like the AAA, like the process of it is bogged down too, because some people just aren't using it correctly.
Right.
So now cases are taking really long to do arbitration now, but it's like
sometimes also.
I'm sorry.
Yeah, sometimes also about settling the dispute too. So when you make the point that things are taking so long, is this also perhaps an attempt to get people to forget about it or give up on it? It's like if you could solve a problem in 2 days, or you could solve a problem in 2 years, and because they're not actually getting anything done or dragging out the process, is this causing more and more of these cases to go away? And I think this matters a lot. And this is another interesting, just from some quick numbers here, from a state court standpoint. So everything we discussed prior to this was from the federal level. From a state court standpoint, don't have as much data, but back in 2007, it was about 150,000 trials by jury, and then down in 2021 to about 48,000. So that's roughly, that's a 66% reduction. Talking about 33% of the original amount. So we're seeing this everywhere. And again, it's like, hey, I get it. Everybody's busy. Nobody really wants to go serve on a jury. But these fundamental rights, the point of this is the checks and balances systems that we have. I had a family member one time make a comment to me. It's a little off topic, but she made a comment to me that if I didn't like what was going on in politics, I should just go vote. She literally just said, if you don't like what's going on in politics, then you should just go vote. And that was it. And I remember thinking, and I said this to her, and I said, that was a super duper oversimplification that you just had. Like, it is not that simple to make a change by me just walking into a ballot box and casting my ballot for whichever candidate that I felt was, the right choice. And I think about a jury of my peers, and I go, these people are deciding a set of facts. They're making a very big determination, but it's also an incredibly important determination. In my opinion, it supersedes that of casting your vote, because you can really actually make a difference here. You're talking about, putting out these changes and saying, hey, and it's not even a standpoint of criminal. Let's say somebody's guilty and they're just taking the case to trial. Then he has to have to evaluate it objectively, whatever the evidence is. But a lot of the times in civil cases, it's like, well, what type of society do I want to live in? And then can we make a difference being part of a jury? And I really think that we can.
Yeah. It's definitely a great civil responsibility when, and it's sad that it's viewed as a burden. Like, oh, I got jury duty. I have to go spend however many days in court and figure this out. But it's like, no, that person needs you. They need to sit there so that way they know everything is being, treated fairly. Because otherwise, sometimes it's the judges and the lawyers get together and they decide it. And then
Right.
things aren't as fair as, you would hope had it. So
I think we know that over and over that a lot of decisions are made before anybody steps up on the bench. So the real question that we need to start asking ourselves is, why are trials disappearing? So, well, here's the short answer: efficiency. But as you go a little bit deeper, it gets quite a bit more complex.
So plea bargains. Today, over 95% of criminal cases are resolved through plea deals. Defendants are often pressured to plead guilty in exchange for lighter sentences, even when they be innocent. It's a system that enforces speed, not necessarily justice. So you can see that if you sit in on a Zoom call and you watch these judges just like rifle off the eviction cases, and it's just like, okay, next, okay, next, okay, next, okay. And it's flabbergasting to watch how many contracts that can get going in 30 minutes.
We're wasting time, man. We don't have
Yeah.
time for testimony and all of this. And, that's why they call it if you don't have your stuff in order, it's called a breakout room. You got to go over there and talk about it and, get it together and come back and solve it.
Civil settlements and arbitration. So arbitration is more of the private side. Like I said before, it's mediation where you get to a room with a bunch of lawyers and this says replace trials. Many of these are influenced by fear of drawn-out litigations or costs. Arbitration clauses are usually quietly eliminating the jury option because you're just in a room talking it out. So you're not really enacting any of your rights. You're just coming to equity between people.
And as Stephanie mentioned earlier, like, these are binding decisions. Once it's very common to go to arbitration, but once arbitration happens, it's incredibly uncommon for a trial or some type of court case to take place about the same issue. So that has to be taken into a lot of account whenever a person's asked, "You want to go to arbitration?" Because this is just a very final decision, and if it doesn't go the way you want it to go, maybe you had some evidence that you didn't get to discuss, maybe you didn't know about it at that time, but because this decision's been made through arbitration, you could very well give up your opportunity to take it to a trial.
And when you go into some of these contracts, say, any business, any bank, they have, say you go get a loan and at the end of the loan it says, oh yeah, if you have any disagreements or if this needs to be settled in the court of law, then they put in like an arbitration clause. So if you don't go by the clause, you don't do arbitration first, it's like not starting at the state level and just going straight to federal. It's like you have to exhaust that option before you can even think about filing in state court.
Yeah.
So you have to exhaust the clause and do the administrative process correctly. So if you file straight into a court, they can dismiss it for the arbitration clause.
And then at the same time, you would also forfeit your right to try again. So it's very important to follow procedure. Procedures have to be followed in the correct order. Otherwise, you're just going to shoot yourself in the foot. And it's
especially
over.
in the court system, for sure. Yeah. Structural pressures. Judges and prosecutors favor efficiency. Courts are overburdened. Jury trials are costly and time-consuming. The system nudges everyone towards resolution outside of the courtroom.
Yeah.
So,
I see this a lot especially when talking about public defenders or somebody who's just facing some type of charge or whatever. It may not even be anything that serious, but it's just about the fact that it's like, oh, I don't actually want my life to be burdened from this. It's like, oh, sure, I did it. It's disorderly conduct or something like that, and people are just making a plea deal. Why would I drag this situation out? I've already, say somebody admitted to something. Why take the point? Why go to trial in that anyways? So if you make mistakes, especially from a criminal side, it's like, yeah, it's just easier just to take the plea deal. And next thing you know, here we are, another one, no trial. Just happens over and over and over again.
Absolutely. So, and then there's also loss of legal education and participation. So many Americans don't actually understand their right to a jury of your peers or how to invoke it. Others avoid jury duty. The civic fabric is fraying. We kind of touched on that. But Mark and I actually looked into this, and how to invoke a jury is you have to just write a demand. And you have to pretty much just say, I demand the right to a trial by jury by my peers.
It would be very similar to drafting a motion if you know how to do that, or it's not that hard to draft a motion, but it's basically just put in there, I'm going to formally demand that I invoke my right to a jury trial.
Yeah.
They can't say no. They might try to pressure you out of it. They might say, well, you sure you want to do that? Then we have to do all these different things.
And then try and scooch you into a plea deal. Like, wouldn't you just like to take this deal?
Yeah.
Wouldn't that just be so much easier? No, I want my jury trial.
That's why I wrote the motion.
But there is also two different jury trials, there's the bench trial, and then there's also the jury trial. So then the bench trial is literally no jury, and it's just a judge listening to two parties and their witnesses, and then see their evidence and have the whole spiel.
Right.
So
we see this all the time. It's Judge Judy, and then from a standpoint, like, again, you can take a case to trial from a criminal standpoint, or you can take a plea deal or whatever may happen with that case. But in that, let's say you invoke your right to, trial, then you're talking about, is that going to be a bench trial or is it going to be a jury trial? And if you go to the bench trial, and the judge hears everything, and you're hoping that the judge will take your side. But the jury, typically, you don't see a lot of people doing that. It doesn't happen very often.
But again, the judge is just one person, and I feel like a jury trial is more fair because you have 12 other people deciding the fate. Not just one, or not just a judge and a lawyer. So, do whatever you want to do, but I think it's great information.
Yeah.
Because I feel like people don't actually know the names of the bench trial versus jury bench trial.
So now let's take a look at some different, arbitration ramifications. You talk about companies like Amazon and major banks, and they're using, at least a lot of the times, to sidestep the courts. We have touched about this earlier in the segment. We just want to drive home the point. There's a lot of fine print in these, like they really do, especially when it comes to arbitration clauses. They're typically going to put in there that you're going to waive right to a jury trial. So even these security agreements that we so nonchalantly sign every single day, they're trying to get us to give up that right. They're banning class actions. They're requiring private resolution. And the biggest thing with this also is so that you can't, discuss these things with your peers. Like you can't act, like how many times people are like, oh, I had to sign an NDA. Like this situation happened, and then I had to sign a non-disclosure agreement. And that was even just to, settle the arbitration. And the point of this is so that we don't actually know what's going on. And it's very difficult to hold people accountable, hold companies accountable. We don't actually know what's going on.
Right. Lots of backdoor deals and, secret private meetings and
Right. Those, it's
not public anymore. Right.
There's tons of legal ramifications to this, talking about losing Seventh Amendment rights. You can't appeal anything. Arbiters, they typically favor the companies or the banks because they're paid from these people. So it's not exactly like they're not biased in the situation. That's typically an issue. And they definitely lack transparency, as we were just talking about. So there are different cases that settled some arbitration things. These are much more recent. We're not going to talk about this too much in today's episode, but it's a really great information to look up if you want to do that. So this was a 2011 case, AT&T Mobility versus Conception, upheld arbitration clauses even when they banned class actions. So again, that's a little bit stripping away the rights. Epic Systems versus Lewis, 2018, allowed employers to bar true lawsuits for labor violations. God, I can't even say that with a straight face. Like, oh, there was a bunch of labor violations, but we're not going to allow you to do like a RICO situation and combine all this together and like really hold these guys accountable. Yeah.
Yeah. No, there can only be one plan.
Yeah. No, exactly.
Yeah.
Come on, we're the big dogs, and we're going to take down the little dogs standing in the corner. How much more David and Goliath can we get? Lambs Plus versus Varela. This is 2019. And this denied class arbitration unless explicitly stated. So again, another class action thing. Oh, all right. So now we're going to transition into why does this matter? The disappearance of jury trials has real consequences.
A weakened public oversight of justice. Like I said, one person, judging your case versus 12. It erodes the Constitution by turning rights into a formality. So it's just a formality for a judge to sit in the court and hear the witnesses and look at your evidence and to preside over it, which you can do that in the chambers, right? So then they don't really have to uphold the Constitution in the court once you cross the floodgates.
Oh, it's just getting in the way anyways, right?
Yeah, right. Because then you're really just in codes and statutes, and that's not where the Constitution lies.
Right, yeah.
So that's rough, but then if you had 12 of your peers, they would be like, no, we have rights, so this would be wrong. And they would talk it out, and they would come to an actual agreement of right and wrong on a situation instead of someone just presiding over it. It limits accountability for corporations and the government. So kind of like what I just said, with people understanding their rights or hoping to anyway.
So we're seeing so much of this in today's day and age. I mean, we're becoming a very digital world. And on top of that, there's so many licensing agreements and security agreements. And like, I mean, just you say like PlayStation Network or whatever Xbox has. I know I'm showing I don't play as many video games as I used to. But all of these things that we just agreed to, credit cards, mortgages. I mean, heck, there's something that you have to agree to watch a movie at a movie theater. You understand? Like, it's everywhere. And that's the stuff where we're just so freely going, no, it's cool. Something can happen, but I'm just going to give up my ability to actually defend myself, actually stand up, actually have other people be able to sit in unbiased and look objectively at a situation and come to an equitable solution. I'm just waving that out, and it doesn't even matter anymore. So
liability waivers, yeah. You gotta love them.
I was at Dave's Hot Chicken, and if you want to get the hottest hot spice at Dave's Hot Chicken, you have to sign a waiver just to eat your lunch.
Just to go to the gym, you have to sign a waiver of liability.
Absolutely.
Just to go to like a trampoline place, you have to sign the thing of liability.
Right. Everywhere. And I think that so many people like, oh, I just want to go have fun. I just want to go do this. And that's totally fine that's your intention.
Sign my security agreement.
Yeah, right? It's cool. No big deal, right? Yeah, actually, well, it kind of is. And if you ever read it, if you ever sit down and really read a security agreement or a licensing agreement or these documents, I think you're going to really be intrigued at like what information is in there and what you're signing and what you're agreeing to.
Yeah.
Yeah, it's a whole bunch of different stuff, I'll tell you that. So I think that as we wrap this episode up, looking back, trial by jury is one of the last places where everyday people can actually directly check power. But for whatever reason today, this seems to be vanishing. We seem to be pushing these deals privately. A lot of arbitration, as we talked about. So really, the next time you see a user agreement or an employee contract, what rights am I signing away? What am I really giving up just so that I can go have this little bit of fun? And is that actually worth? Is that worth all of this?
But here's an ending thought, but if the government can't interfere with private contracts, they're still using the Constitution, but only in the way that they want to.
Right. Yeah, they're really coming back and saying, "Hey, no, we can do this, but because of our
But
government
only so
authority."
much.
Yeah, but because of our authority.
Yeah.
Okay.
Take what they want, leave what they want.
Right.
Man, I wish I had that
Man,
one.
if only, right? Well, anyways, so thank you guys again so much for coming to join us today. This is Things We Don't Talk About, and I'm Mark Daniel Maslin.
I'm Stephanie.
Can't wait to see you next time.